Good morning, everyone that joined us today, and welcome to TMA's International Coffee on Insolvency in BVI in Cayman. Well, firstly, many thanks to TMA's institutional sponsor. I'll be moderating the panel today, our discussions. And for those who don't know me, my name is Liv Machado. I'm a partner at Tauil Chequer in association with Mayor Brown. And we have here two international speakers. I'll start introducing them. Jason Robinson is a director at Teneo in Cayman Islands, having joined Teneo following its acquisition of KPMG Cayman Island restructuring business. Jason has over 14 years of experience assisting clients in the financial services sector and has played a central role in various cross-border restructuring and insolvency matters. Jason is a CPA of Canada, qualified insolvency practitioner in the Cayman Islands, and a fellow of International. Grant Carroll is a partner in Ogier with over 15 years of experience, firstly as a barrister in the UK and for nearly 10 years in the BVI. Grant was BVI counsel to Constellation Oil Services and worked on its restructuring, and is lead counsel to the liquidators of the collapsed crypto hedge fund Three Arrows Capital Limited. Grant is also a BVI counsel to the provisional liquidators of FTX Digital Markets in the Bahamas. And Grant currently is the chairperson of BVI RISA, Recovery and Insolvency Specialist Association. We also have here João Ricardo Pacca, partner at Campana Pacca Advogados, and he'll be reporting our discussions today. If you have questions, please feel free to write the questions in our YouTube chat, and we will address to the speakers as soon as we have a chance. So thank you, Jason and Grant, for accepting TMA's invitation. And to start with our discussions, Jason, could you please provide us with an overview of the insolvency system in Cayman, which types of liquidation are available, how the procedure works?
Yeah, thanks very much, Liv, and thanks everybody for having us here. Both Grant and I were both in Rio at Insol earlier this year, and so it's great to be back virtually, at least, speaking with everybody here. In terms of the Cayman Islands restructuring regime, I thought it would also just be helpful to give just a brief overview of the Cayman Islands generally. As the name suggests, there are multiple islands. We have 3 islands with a whopping population of between 65 and 75,000 people that live across our islands. But yet we are a major international financial center. As you'll be aware, there's various investment funds, special purpose vehicles, financial institutions, insurance companies that use the Cayman Islands. There's a number of entities with investors or stakeholders from Brazil and just anywhere across the world that use the Cayman Islands. We do have a strong regulatory framework here. We have over 25,000 regulated investment funds that are based in the Cayman Islands. And we have the Cayman Islands Monetary Authority that regulates the industry. From the court system, we have the Financial Services Division of the Grand Court of the Cayman Islands, and they hear the restructuring and insolvency matters. We have a Court of Appeal, and the highest court is the Privy Council in the United Kingdom. The laws in the Cayman Islands, they're based on English common law, and we have 2 primary legislations that deal with our restructuring and insolvency rules. So we have the Companies Act and the Companies Winding Up rules. And in our restructuring and insolvency matters, you primarily have your insolvency practitioners. Those are typically accountants or registered or regulated insolvency practitioners who have licenses in other jurisdictions as well. And they have to have certain qualifications, certain experience requirements, and residency requirements in the Cayman Islands. You can have foreign practitioners also acting alongside Cayman Islands practitioners. And we have a strong legal practices in the Cayman Islands as well that are also regulated here. So it's a very robust system. We're used to dealing with a lot of high profile cross-border matters, and the system is really set up to do so. The regimes itself, we kind of group it, and you're going to hear a lot of similarities between Cayman and BVI, but for the Cayman Islands specifically, we have the solvent or voluntary liquidations. Those are, an entity is at the end of its useful life. The shareholders or the partners or whomever want to wind up the company, and it's just more of a filing exercise. There's advertisements that are required. You go through the process, realize all the assets, pay the liabilities, and the stakeholders get their money back. I think for this group, the more relevant is the court appointments that we have. It's typically for insolvent companies, companies that need to go through a restructuring, and we have three primary procedures to deal with that. So we have the provisional liquidation, we have the official liquidation, and as of last year, in August 2022, we now have a dedicated restructuring officer regime to deal with restructuring of companies. We did previously use the provisional liquidation to deal with restructurings, but the restructuring officer regime is now dedicated, and we can go through that later on. Just to touch briefly, the provisional liquidation is primarily used where there is risk of dissipation of assets, where there's concerns around mismanagement. A creditor believes that there's a prima facie basis to wind up the company, but they're concerned that something may happen before the winding up hearing may be heard. We had an example a number of years ago. We were appointed over a fine wine fund. They bought and sold fine wine out of Bordeaux. There was potential risk of where the inventory would go in the meantime. So we were put in as provisional liquidation. Provisional liquidators hold the fort until such time as the winding up hearing could be heard. The official liquidation, the second procedure, that is an end of life procedure. That is, the company has no longer any reason to exist. We need to wind down the company. We need to put in independent liquidators, and their mandate is to realize, collect the assets, investigate if there's any claims, and to pay creditors, and if any surplus, pay shareholders. Within that procedure, it's typically an insolvent procedure where the company is unable to pay its debts as they fall due. But you can also go into an official liquidation if the shareholders are not happy with management. There's a breakdown there, and they want to apply for independent liquidators to come in on a just and equitable basis. We are currently appointed over a credit fund that has a number of operating entities and subsidiaries, actually in Brazil and in Argentina. We were put in on a just and equitable basis by the shareholders' application. We replaced the current investment manager, and we have a new investment manager that's helping to wind down the portfolio. So even though I reference that as being an end-of-life procedure, depending on the assets, depending on the investigations required, that process can carry on for quite some time. The third procedure is the restructuring officer regime, and that is dedicated to where we want to restructure a company, where the company intends to compromise with their creditors. And there's a framework around that that allows for the directors themselves to put the company into a process to petition to put in restructuring officers. Those restructuring officers can act alongside the company in advance as in a financial advisory role. And the restructuring officers are there to work with the company, to monitor, to report back to the court. There is a moratorium immediately upon the filing, so it gives the company breathing space while they can work with stakeholders to develop that restructuring plan. And it's a new procedure for us, although it it's effectively taken what we previously had in the provisional liquidation. There's still the ability to compromise debts through a scheme of arrangement. Yeah, that's in summary I'd say the three main court appointed procedures.
Thank you, Jason. And Grant, as Jason mentioned, there are some similarities, but of course, also relevant difference. So can you also walk us through an overview of the BVI insolvency system? Yes, you muted, Grant.
Apologies, I'm off mute now. Thank you very much for the introduction, Liv, and to the TMA audience as well for taking the time to come here and listen to us. So the British Virgin Islands is a British overseas territory. It's located in the Eastern Caribbean. It's a self-governed separate territory, but it's ultimately overseen by the United Kingdom. It consists of over 50 small islands. The largest island is around 12 miles by about 2 miles at the widest. We've got about 30,000 people in the Virgin Islands. And according to a recent report by the government, there are currently approximately 375,000 companies incorporated in the British Virgin Islands. And it's estimated that this supports around 2.3 million jobs globally and generates an extra 14 billion each year in taxes for governments worldwide. If we break that down to the UK, purely as an example, it's estimated that BVI companies hold an estimated $153 billion worth of assets, and it supports around 134,000 jobs in and around the United Kingdom. In terms of the insolvency regime, we also have in the BVI separate mechanisms. One is what we call voluntary liquidation, and the other is insolvent liquidation. But it may be easier to think of them as a solvent liquidation and an insolvent liquidation. You would use typically the voluntary or solvent liquidation process when the company's use has reached the end of its life. So the holding company or the members of that company no longer need it. For example, it may have held an asset and it's now sold that asset and the company now has no further use. So in that circumstance, the directors of the company would need to make a declaration that the company is solvent. And that needs to confirm two things: is that the company will continue to be able to discharge its debts as and when they fall due, and also that the value of the company's assets is equal to or exceeds its liabilities. The voluntary liquidator must be a BVI resident and have suitable experience. And once the voluntary liquidator has been appointed by the directors themselves cease to have functions and powers, but they remain in office. There's obviously a lot more to voluntary liquidations and solvent liquidations, but that is in an overview. The other process by which we would operate would be insolvent liquidation, which I think many viewers will be more familiar with. And that is an application that can be made by the company itself, a member of the company, a creditor of the company. That's probably what we most commonly see. The BVI tax authorities or the Attorney General. The liquidator who is to be appointed must be a licensed insolvency practitioner in the British Virgin Islands, and they need to have consented to act prior to the appointment. The primary ground for appointing liquidators, certainly by a creditor, is that the company's is not able to pay its debts as and when they fall due. So typically you'll have a creditor who's owed an amount of money, and they will seek to appoint a liquidator to dispose of the company's assets and pay out the creditors. Now, what is helpful in the BVI regime, and Jason will correct me if I'm wrong, but I believe also the Cayman regime, is that it's possible to appoint foreign-based liquidators to assist here. So in this instance, we would have a BVI resident liquidator together with a foreign-based liquidator, and that can be done for many reasons, such as time zone support, local knowledge on the ground, and also familiarity with other systems where assets will need to be realised. But it's certainly in the BVI, at all times, you will need the BVI resident liquidator together with the foreign liquidator. From the moment of appointment, the directors of the relevant company again cease to have any powers, but they do remain in office. And all of the powers of the company shift over to the liquidators so that the liquidators may carry out their duties and functions. Now, the primary function of the liquidator is to gather in the assets of the company and realize those and sell them so that they can pay creditors as much as possible. The liquidators are given additional powers to do this, and they have powers, for example, to carry on the business of the company if the company needs to be traded for a period of time. For example, if there are perishable goods that aren't able to be sold imminently, the company may need to continue trading. And the liquidators are also given additional claims that they may bring. Now, these are claims such as unfair preference, which is where one party may have received, for example, early repayment of a loan. I'm sure Jason and I have both been involved in cases where a company, for example, has been liquidated on the, let's say, the 1st of March, and on the 25th of February, a large payment has been made to pay down a debt a few days before the company went into liquidation. That may well be considered an unfair preference because that particular creditor would have been preferred to all of the other creditors. And therefore, liquidators would typically investigate those kind of claims and then seek to gather that money back in for the benefit of all creditors. Again, other claims that a liquidator could bring would be an undervalue transaction. For example, if the company has sold off an asset at too cheaply to an individual or another company, then liquidators may seek to unwind that transaction or gather in the difference between what was paid and what the fair market value was. Liquidators will also be interested in looking at insolvent trading and fraudulent trading. Insolvent trading is the point at which any reasonable director should have realized that the company was insolvent, and therefore any continued trading has worsened the position for creditors as a whole. And again, there are powers to bring claims against officers and directors who have continued a company long after it should have been wound up. So Liv, that's I think hopefully a high level overview of the system in the BVI, and as you can see, similarities with Cayman as well.
Yeah, definitely. And something that caught my attention, and of course probably the attention of the Brazilian audience, is that of course the regimes are different, the mechanisms are very different from the Brazilian ones, but one thing that caught the eye was the fact that the liquidator may be appointed by creditors, and if I'm not mistaken, Jason also mentioned that the liquidator may be appointed by the shareholders. And in Brazil, what we call is not precisely a liquidator, but it has similar roles, is the judicial administrator here in Brazil. And in our proceedings, the judicial administrator is always appointed by the court. So it's a huge difference from our Brazilian system. And in terms of restructuring available in the jurisdictions, we would like to understand better how restructuring operates in BVI, and also, of course, Cayman. But Grant, if you could start with this one.
Yes, certainly. So Jason touched upon the provisional liquidation regime in Cayman Islands, and we have the same provisional liquidation or incredibly similar provisional liquidation regime in the British Virgin Islands. Principally, this was a tool and a jurisdiction that was developed to protect assets in the short term pending a liquidator being appointed. However, it developed in many jurisdictions to enable companies to get a steady base and ward off potential liquidation from other creditors, to give them time to negotiate with their creditor body as a whole. Now, if one takes the Constellation Oil Services matter as a case study, which I'm sure many people will have heard of listening from Brazil, in that instance, each rig that it owned, each oil rig, was ultimately owned by a BVI company. So you had BVI holding company holding the asset of the rig. That was administered primarily through a judicial, there was a judicial administrator appointed, and it was a judicial restructuring being completed in Brazil. And we needed to support that in both the US and the British Virgin Islands, because that was where lots of the assets were based. So what happened was there was a provisional liquidators were appointed over each of the rig holding entities. They were predominantly BVI, but there was one Cayman rig holding entity as well. And what that did is act as a practical bar to other creditors wishing to place those entities into liquidation, because they would then need to convince the court that they would be better off taking the asset under their control and selling it. And it really is a mechanism to buy time for the company to enter into meaningful, I would say, discussions with its creditor body as a whole. So when you add in an insolvency professional, such as, and we're fortunate to have Jason on the line, when we sort of put someone like Jason in as an office holder, what he can do is instill some faith and belief into the creditor body that it's being taken seriously, that their concerns are being taken seriously, and that their consensual restructuring can be negotiated. Because sometimes the creditors and the management of the company may have reached a stage where they can no longer really deal with an individual. So we'd seek a professional insolvency practitioner to sit in the middle. Now, what the provisional liquidator does is not displace the board of directors in the same way as a liquidator does, but conceptually they sit above the board. So you'd have the board here running on the day-to-day basis, and you would have your provisional liquidator who would sit above the board and would attend board meetings and would be able to participate in the running of the company, but they wouldn't ordinarily participate in the day-to-day running of the company. For example, in Constellation Oil Services, provisional liquidator wouldn't be interested in the company buying tools for the oil rigs, but they would certainly be interested in large payments or disposals of assets, such as if they were looking to sell an oil rig or indeed tender for a new contract. And
Great. Sorry to interrupt you, but
No.
just to understand better, you mentioned that this is a proceeding to buy time. It would be great to understand if there is some kind of stay period or a moratorium triggered by this type of proceeding.
Yes, so there is no exact moratorium provided in the same way as there is in other jurisdictions on the filing of a liquidation application or the appointment of provisional liquidators. There is a moratorium when liquidators are appointed, but a practical workaround is that in the BVI, when provisional liquidators are appointed for restructuring purposes, what a standard term in the order appointing them is that no other party may bring an application against a company without leave of the court. And that is an order that's made, and that is a practical way of ensuring that there is another hurdle for people to overcome on that basis. And that tends to work and has worked in the past. I was just going to add in relation to the provisional liquidation regime, it is a court-appointed regime, and the provisional liquidators can be given as many powers or as few powers as are required for the restructuring to progress. It is a court-supervised procedure, and it would often be the case that the provisional liquidators need to supply reports to the court, often on a 3-monthly basis, might be something quite standard. And they would work closely with the management of the company, the creditors, and then to ideally come up with a consensual restructuring. But also we have schemes of arrangement which would be similar to the cram downs, where you need 75% in value and a majority in number of people attending to vote in order to pass a particular class of creditors to implement a restructuring of any particular debt documents. So I'll pause there for the moment, and I know Jason's going to explain about the restructuring officer regime in Cayman.
Yeah, thanks very much, Grant. And I think it's helpful for Grant to explain that from the BVI in the first instance, because there is a lot of overlap. Practically, how the procedure progresses, even though we now have the restructuring officer regime, prior to that, just like the BVI, we had the appointment of provisional liquidators. I don't know that I would add much to what Grant had said. Much of that applied to how it would operate in the Cayman Islands. Same thing with where we talk about the scheme and the voting. Everything there, it kind of overlaps. So from a practical standpoint, they were very similar. What we did in the Cayman Islands is we implemented this new restructuring regime and made a few maybe enhancements or specifications to the procedure that have been found to be helpful or thought to be helpful as part of any restructuring in Cayman. So there's kind of three things that I just want to touch upon or highlight in the restructuring regime. First is the appointment mechanisms. So it has now been clarified that the directors have the power to initiate the process. So although Cayman is a very creditor-friendly jurisdiction, the restructuring regime now gives the directors the power, the explicit power to make this restructuring officer filing. There previously in the provisional liquidator appointment, we had a large restructuring go through the jurisdiction in the last couple of years. It was the restructuring of Luck and Coffee. It was based in the PRC in the coffee business, and they, in order to put it into a provisional liquidation, they had somewhat of a friendly creditor file a winding up petition against the company, and then the company filed to put in provisional liquidators for the purpose of restructuring. Now the company itself can make the application to apply for the restructuring officers to be appointed, and the moratorium which Grant referred to, or the stay, is effective on the filing of the petition now in Cayman. So there's no unsecured claims that can be brought against the company without leave of the court. There is still a carve out for secured creditors. Secured creditors can still make claims on specific assets that the company holds, irrespective of the process that's ongoing. But that stay is in place. When the filing is made, the hearing for the restructuring officers is within 20 days, but that moratorium is in place until that hearing date, and then it continues if the restructuring officers are appointed for the very same purpose that Grant talked about in terms of reaching a consensual agreement with creditors or stakeholders, or implementing a scheme to come to some sort of arrangement. The third aspect that I just wanted to talk about is the flexibility of the process. From a practical perspective, similar to what Grant mentioned, the whole purpose here is for the company to restructure, for it to deal with its stakeholders, for them to interact together. The restructuring officer is there as an independent third party, sitting above the process in a monitoring role, in an oversight and supervision role. They report to the court. They act as an intermediary, and so they can be a powerful tool as part of that process. As well, and this was similar to when we had the provisional liquidation process, the orders that are made by the court can be tailored to the process itself. So not only on the initial date of the order being made, if there's an anticipation of certain work streams that are going to need to happen, if on day one of the process it's anticipated that there's going to need to be a sale of an aspect of the company, or there's going to need to be funding raised, or some critical aspect of the business, you can seek some sort of powers for the restructuring officer or the provisional liquidators at the outset. And in the absence of that, the restructuring officer or provisional liquidator has the ability to go back to the court and seek the power for those things to happen. So it is also understood to be a process of urgency, obviously, as we go through a situation of distress. And so the courts are generally very available as need be to hear any urgent applications through that process.
And I know both of you mentioned, of course, cross-border cases, but it would be interested to hear if your jurisdictions do apply the UNCITRAL model law, if your jurisdictions adopted the UNCITRAL model law, and how it works in practice.
So the BVI is not a model law country, so we don't have a recognition procedure akin to the US Chapter 15 recognition procedure. So in the BVI, a foreign appointed liquidator or office holder would need to apply to the BVI court on a case-by-case basis for assistance. There are a limited number of countries that are on a specified list of who can get immediate recognition under statute, and then we have common law assistance, which is provided as well. Now, I do know that in the BVI, that is something that is actively being looked at in relation to providing assistance to foreign based insolvency professionals, as other jurisdictions are doing.
Yeah, and it's a similar situation in the Cayman Islands. We have similar from we're very open because we're used to the cross-border aspects of cases. Depending on, obviously, we have the ability to seek, if it's a Cayman Islands company, we have the ability to seek recognition in other jurisdictions, depending on what protocols are available there. The courts here, we had a matter from a protocol perspective. We were appointed over some financing vehicles as part of the LATAM Airways Chapter 11 process in the US. We entered into a court-to-court protocol between Cayman, the US, and the Chilean courts. So there's definitely a collaboration. It's a jurisdiction that recognizes the cross-border nature, but also similar to the aspects that Grant mentioned.
Thank you. I was just asking that because Brazil recently adopted the UNCITRAL model law, so I think the audience would be interested to hear from your experience in your jurisdictions. So moving on, another topic that is very interesting is the asset tracing. So with regard to asset tracing proceedings, could you clarify the mechanisms that are available in your jurisdiction? So we can start with Jason in this one, please, Jason.
Yeah, no, thanks very much, Liv. I think just taking a step back, as we mentioned at the outset, so when we come in as liquidators and we're appointed as liquidators, we take full control of the company. We have full responsibility of the company. Like Grant mentioned, the powers of the directors cease. There is an ability to give directors certain powers back if the liquidator deems it appropriate to do so. But in doing so and having full oversight over the company, we also have the right to all of the information that belongs to the company. We have the right to all the assets that belong to the company. And so we have the ability to collect all the books and records. There's provisions within our statute that require cooperation with the official liquidators by key parties, by directors, by officers. We can apply to examine those individuals. We also and key service providers as well, and the ability to require them to deliver information to us. Now, from a practical perspective, there may be some shortcomings in terms of examining those parties, depending on the jurisdiction where they're located. So we have in instances where you have a director who's not physically located in the Cayman Islands, and so even though the Cayman court has said you must deliver up information to the liquidator or you must be examined, they may ignore that order. If they're not resident here, they don't plan to come back to the Cayman Islands. So that's where we would utilize the ability to seek recognition in certain jurisdictions in order to gain that information. Within the last few years, we were appointed over an insurance company here in the Cayman Islands. There's actually a number of stakeholders in Brazil and Latin America, but the company was primarily being operated from the United States, and a lot of the assets were based in the United States. And so on our appointment, we sought Chapter 15 recognition in the US. And upon that filing, we immediately had a temporary restraining order against dealing with any of the assets and records of the company. We were also able to, with that, go in and to the premises where all the records of the company were held. We have an e-discovery team who was able to image all of the computers and hardware that belonged to the company, and we were able to collect that information for further use. And so as part of, I guess I say all this because as part of an asset tracing exercise, the first part of that is getting access to the information. Another key tool in that example was you can then use some of the powers of discovery that are available in those jurisdictions. So with the Chapter 15 recognition, we were able to use Rule 2004 subpoenas in order to subpoena individuals that are resident in there. They would obviously be more likely to adhere to a U.S. bankruptcy order and provide the information that is required. So we have the ability to seek recognition in jurisdictions where those people are located and seek information from those parties. Once we have that information, it is our duty as liquidators to investigate what's happened with the company. We have tools to do so. But that's just a general overview in terms of us getting the information, because once we have the information, you have a full history of what's happened with the company. You then can use that information to formulate any claims that you may have. Grant talked in detail about the various claims that can be brought under kind of our jurisdictions. They're very similar with the preference claims that undervalue, and then depending on where you have recognition, you may be able to also bring claims in those jurisdictions as well, against parties where they are. So it's very powerful in our appointment to be appointed over the company, have all the rights of the company, and then be able to pursue any claims or any assets that belong to the company, both in our jurisdictions, but also in other jurisdictions around the world.
And Jason, you mentioned there is a duty of investigation, right? But with that duty, the liquidator has like powers to actually investigate, or you make the investigation in accordance with the information you simply get from the company? How does that work in practice?
Yeah, so we have, we have the power to investigate what's going on in the company. And so we gather the information and we investigate whether there's any claims or any assets available to be pursued. I think as well, we obviously have a duty to act in the best interest of stakeholders as well. So any investigation that's undertaken also needs to be proportionate to the potential outcome. We need to understand what has gone on, but we also, need to be, the end goal is to try to maximize returns for stakeholders, whether that's the creditors in an insolvent situation or if there's a surplus to shareholders. And I think another key tool to talk about is in terms of we have the concept of a stakeholder committee or a creditors committee in an insolvent liquidation. So maybe I just talk through that a little bit, that on our appointment, we advertise for creditor claims. We have listings based on the records of the company, and we have the ability to ask for a statement of affairs from the directors to really understand the financial position of the company. We then hold a creditors meeting, and at that creditors meeting, one of the key things is to appoint a creditors committee in the case of an insolvent company. And that creditors committee is made up of a representative group of the creditor body as a whole. We'll have 3 to 5 creditors that sit on that creditors committee, and that committee, they sign non-disclosure agreements, confidentiality arrangements, and they are privy to information that relates to the strategy of the liquidation that we may not send out to the wider body of creditors while we're pursuing recovery of assets. And so that creditors committee is there to act as a sounding board for the liquidators. Because they've been involved with the company, they may have additional insight or information that's helpful to the liquidators in their investigations. And they also feed back the sentiment of the creditor body as well. That's helpful for the liquidators as they're going through that process.
So the creditors committee has a very important role. It's interesting to make a parallel with the Brazilian legislation. We have also a provision of having a creditors committee formed, but at the same time, Brazilian bankruptcy law provides that the committee may be held liable for execution. So it's rarely formed in restructuring cases here in Brazil. So before moving to Grant, I would like to encourage our audience to send questions, because we'll reserve the last minutes for questions as well. This is a great opportunity to hear more from BVI and Cayman. So Grant, the virtual floor is yours.
You're just on mute.
Thank you, Liv. What I won't do is repeat everything Jason's just said, because the regimes in Cayman and BVI are very similar and based upon predominantly an English common law system. But if I pick up at the creditors committee stage, so in the BVI, a creditors committee can be a maximum of 5 creditors, and that would generally be appointed at the first meeting, and will often be done on a weighting voted threshold. So whoever has the biggest debt effectively has the most weighting towards their votes when they are seeking to join the creditors committee. But once you have your members of the creditors committee, it's 1 member, 1 vote. It doesn't matter if one creditor has a $10,000 debt and another creditor has $1 million debt. They are both have equal voting power. Certainly in the BVI, and I think the case is the same in Cayman Islands, that the creditors committees don't have power per se. They can't direct the liquidator to carry out certain actions. They are there as a sounding board and to assist the liquidator in discharging the duties. So as Jason alluded to, if the liquidator is thinking about bringing a certain piece of litigation or embarking on a particular course of investigatory action, that may take a long time or is likely to cost, for example, quite a lot of the money of the estate, then they would go to the creditors committee first and say, what do you think about this? Do you have any views? Do you have any expertise that you can share? Because often the creditors will be involved in the industry that the company that's now insolvent was operating in. So for people like Jason, when they're carrying out their investigations, the creditors can be absolutely key, and their advisors. That's a bit different to the American system. If people are familiar with dealing with sort of Chapter 11s and 15s, where the creditors' committees have a lot of independent oversight power. The other part I thought it would be helpful to touch upon would be Norwich Pharmacal orders and bankers' trust orders. Now, what these they don't have to be used within an insolvency context. But for example, if Liv, you have a client who has, say, been a victim of a fraud, and they've been able to trace money, and let's say they've seen it leave, they can trace the money out and it goes to a company in Cayman Islands or BVI or Bermuda. I've come across this perception where people can think, well, that's the end of it. I can't trace it any longer or anymore. But what we do have is a jurisdiction called Norwich Pharmacal relief. And what that enables a victim to do is to find out information about a particular company without that company necessarily finding out that it's occurred, that the application's been made. And the jurisdiction is founded upon the fact that an innocent third party has been mixed up in a wrongdoing. So you'd have to show that there's been a fraud or someone suffered a loss attributable to another party. But for example, in the BVI and Cayman Islands, where we have the registered office, registered agent concept, we can bring in an application which would compel the registered agent to provide us with information on the beneficial ownership of a company and that company's books and records, such that you would then be able to trace who owns it. And if necessary, you could look at piercing the corporate veil, or when you have the resolutions, you can trace the money through. Now, crucially, what can often help is finding out how the registered agent was paid. So the registered agent would disclose the bank account that transferred them their fees, and then you have another string to pull on. And again, someone with Jason's expertise would then trace that money around the world, wherever that may have gone. And then the very similar jurisdiction is called bankers' trust, and that's the same, pretty largely similar to Norwich Pharmacal jurisdiction, but it would be specifically against banks. So you're trying to get information out of banks when you've seen the money go there. Now that's a lot more important in Cayman, where there's a large banking industry. We don't have that many banks in the BVI in comparison to other offshore financial centres. The other, if there's no questions at the moment, the other bit I would touch upon would be receiverships in support of orders or to investigate powers. Now, again, this is typically a insolvency practitioner who would be appointed. And if, for example, we're able to obtain a freezing injunction, we might also be able to obtain an order appointing a receiver over the shares in a company or the company itself or a specific asset. And the receiver would take control and be able to vote the shares and change the boards and secure the asset, very much in a similar way to a liquidator, but it's a slightly different power available that could be brought to bear to secure assets. Or alternatively, if a client or a victim finds themselves in a position of having a judgment and an order that says somebody owes them $1 million, for example, X amount of money, then the receiver can be appointed what we call a post-judgment receiver to collect in the assets and chase those wherever they may be. So that's some other tools available in the offshore jurisdictions.
Thank you, Grant. So we have a question from the audience. What are the requirements for creditors placing a debtor into involuntary liquidation in the BVI and in Cayman, and what are the facts?
Perhaps I'll go first, Jason, and then you can chip in afterwards. So the first thing you're going to need is a debt that you can prove. So that's a contractual debt generally. And you would, at that stage, you would have made demands to the company, and the company would have either denied it owes the debt, or more likely is just ignored whatever you've said. In both BVI and Cayman, you would then decide you want to appoint liquidators. You would approach one of the insolvency practitioners who are available, one of the firms. They would then need to confirm they're willing to act on the matter, run their conflicts checks, and then we would make the application in court. Now, typically it takes from filing to getting a court appointment somewhere over a month, because there are advertising requirements, and you need to advertise both domestically in the BVI and Cayman, and also wherever the relevant company is doing business, so that the application can come to the attention of the creditors who may be there. Now, if we assume we're successful, so we've gone to court, the other party have defended it, saying we don't owe the money, but the judge at the end says, yes, I find that you do owe the money and I'm going to place you into liquidation, and I appoint Jason Robinson. Now, it's probably best if I hand to Jason at that second point, and he'll tell you what he then does from that stage onwards.
Yeah, thanks very much, Grant. And it's like Grant said, yeah, very the same in Cayman in terms of that process. So then, yes, winding up order is made. Immediately upon that order being made, that's where we step into the shoes of the directors. That's where we have the fiduciary power of the company, to the extent we have the ability to delegate any of those powers back to the directors. But in an insolvent winding up such as that, it's not as typical that we would do that in that scenario. Immediately on day one, that is where we go into the secure assets, secure information mode. We advertise the winding up petition being made. We advertise that where we think the creditors may be. We file with the registrar of companies in the Cayman Islands, so that it's then logged in the registrar system, and you file it on the registered office of the company as well. We also, in anticipation of that being made, we're ready to go on day one to notify all of the asset holders of the company or counterparties that we are now appointed to not deal with the assets or to only take instruction from us. And that's part of that securing on day one. We then go into the next phase, which we talked about earlier, which is we advertise for the first creditors meeting. We also, in advance of that, make an initial report that goes to the creditors about what we found immediately upon our appointment. And so we get information out. We get a creditors meeting there, and we make sure that the world knows about our appointment.
Thank you, Jessel and Grant. We have another question from the audience. We have a couple minutes left, so I think we have time. Mateus Costa is asking that, apart from the importance of the committee of creditors, if there are any procedures for selling the trace assets and using funds to pay the debts in BVI and Cayman.
So, one of the standard powers, certainly in the BVI, that a liquidator is provided with is the power to sell assets. So stage one is to find the asset. Stage two is to sell it. Stage three is to pay out the proceeds of the sale to creditors. And there's what we call a statutory waterfall of payments that Jason will correct me if I'm wrong, but I think operates similarly in Cayman, which is the realized assets, i.e. the cash comes in, it pays the cost of the liquidation, then it pays the unsecured creditors, and there may be preference creditors in there as well, such as government employees and the like. Depending on what jurisdiction you're in, there's slightly different rules. But certainly in the BVI, secured creditors fall outside. It's always worth remembering that if you have security, then you can go and take that security and just realize it.
Jason, do you have additional?
Yeah, very, very similar to what Grant had said. Just the one thing for us in terms of the power to actually sell assets of the company. It's not automatically given to liquidators. It's something, if you anticipate that it's going to be needed, you would ask for it in the appointment order. We have the powers of the liquidators are set out in Schedule 3 of the Companies Act. There's powers that are exercisable without sanction of the court and those with. But then we have the ability to just go to the court and make an application to sell property of the company. In advance of making any application, we seek the input from the creditors committee, which is helpful as part of any application that's made to the court. And the court can hear those applications on a very urgent basis. We sold a subsidiary in one of our liquidations that the cash flow was saying they're going to be out of cash within a week, and the court can move very quickly to hear those applications in order to agree to sell the company.
Perfect, thank you. So we are terminating just in time. I would ask if our speakers have like final considerations.
Sure, happy to go. I guess I just say that we are international centers. We're used to dealing with cross-border matters. We have very good professionals in our jurisdictions who deal with cross-border matters on a day-to-day basis, and we're always available to answer any other questions that may be there. But our jurisdictions touch a lot of areas, and so it's very important for us to make sure that you're aware of what tools are available in our jurisdictions.
I completely echo everything Jason says. The offshore jurisdictions are very much alive to their position within the international regulatory framework, taken good steps over these last years to bring in powers available to help creditors, victims of fraud and the like. There's stable legal systems to do that, and there are good professionals on the ground in all of these places who can assist. It doesn't need if assets are traced offshore, then they can be traced through to be realized. That's what I'd say.
Perfect, thank you. So on behalf of TMA, thank you so much, Jason and Grant. We learned so much today, and thank you for our audience for following us. Thank you.
Thank you so much, Liv. Really appreciate it.
Yes, thank you so much.
Bye-bye.
Have a nice day. Bye.
Bye.
Bye-bye.
Bye.